afternoon students, welcome back to your social science class. In our last class, we have already studied about the Supreme Court and also about the Indian Judiciary. Today we are going to study about the High Court and the Subordinate Court. Okay, at first we will study about the High Court. Now, see students, in India, for 28 states and for 9 union territories, we have 21 high courts. How many high courts do we have? 21 high courts. Actually, what happened, last day I was telling you that for some of the northeastern states, as the population is very less, okay, 2 or 3 states, they have a similar high court or they have a single high court, okay, for 2 or 3 states. Why about the northeastern states only? In fact, in Punjab and Haryana also, both the states have a common high court, that is at Chandigarh, okay. Now see students, High Court deals with cases only that falls only within its own territory, okay, or that falls only within its own state, okay. Now, how are the judges of the High Court appointed? Now, the High Court have a Chief Justice. The Chief Justice of High Court is appointed by the President after consulting with the Chief Justice of the Supreme Court, okay. And what about the other judges of the High Court? The other judges of the High Court are also appointed by the President of India in consultation of the Chief Justice of High Court. Okay. Next, what are the qualifications required for becoming a judge of High Court? For becoming a judge of a High Court, a person should be a citizen of India. That is the first criteria or the first qualification. Second is, he can also be or he may also be an advocate of the High Court for around 10 years. Okay. Not only that, he can also be a writer in the field of law, or he can also be a distinguished jurist. Then only the President appoints him as the judge of High Court. Okay. Now, what is the tenure or what is the term of office? A judge of High Court remains in his office till he attains the age of 62, okay, till he attains the age of 62 years, okay. But before 62 years also, his office may fall vacant. In case of an uncertain death, okay, his office may fall vacant, or he can also be removed from his office. If he is found corrupted, then also he can be removed from his office by again that same process of impeachment, okay. He can be removed from his office by the process of impeachment. Now, what about the salary and the allowances of the judge of High Court? The salary and allowances of the judges of High Court may keep on changing from time to time. It may change, it may be it is actually decided by the Parliament, and it keeps on changing from time to time. But always remember children that the salary and the allowances of the judges of High Court also are always charged from the Consolidated Fund of India, okay. Now, we will discuss about the jurisdictions of the High Court. First comes the original jurisdiction. So, what about the original jurisdictions of the High Court? Under original jurisdiction of the High Court, the court may hear any dispute, that is, cases related to any dispute within the state. Okay. Not only that, in fact, under Article 226, the High Court can also issue writs. Okay. In case of violation of fundamental right, the High Court can also issue writs to protect the fundamental right of any person. Okay. Next comes the appellate jurisdiction. What comes next? Appellate jurisdiction. Okay. Now, in case of appellate jurisdiction, the High Court may accept the cases related to both civil case and criminal case. Okay. Now, if any person is not satisfied with the decision of the subordinate court, he can or she can definitely move up to the High Court, and in that situation the High Court can also give a fresh verdict related to that particular criminal case or civil case. Okay. Now, so these are the original and the appellate jurisdiction. Next we will discuss about the advisory jurisdiction. We will discuss about the advisory jurisdiction of the High Court. Under the advisory jurisdiction, the High Court can definitely give suggestion to the subordinate court. That Article 227 and 228. These two articles deals with the advisory jurisdiction of the High Court, and it clearly states that the High Court can act as a supervisor or superintendent for the subordinate courts. Okay. So, these were the jurisdictions of the High Court. Next we will move on to the subordinate courts. The courts at the district level or at the local level are usually known as subordinate courts. They are known as subordinate courts. Okay. Now, the subordinate courts or the district courts can be of various type. Okay. But in your book, you have only revenue court, Nyay Panchayat and the Lok Adalat. Okay. At first, we will study about the revenue court. Now, see students, the revenue court always deals with the matter related to collection of revenue and property taxes or any other money matters. Okay. Now, what are the different types of revenue court? The different types of revenue courts are the Board of Revenue, Board of Revenue. This is at the apex or at the top in the state level. Okay. Next comes the district collector. Next comes the district collector. This is at the district level. Okay. So, these are the two types of revenue court in every state. Now, we will discuss about their Nyay Panchayat. Okay. Now, Nyay Panchayat exercises with the jurisdictions basically at the village level. Okay. They deals with petty cases related to both the criminal as well as civil cases. Okay. Now, if somebody is not satisfied with the judges of the with the decision of the Nyay Panchayat, they may definitely move on to the higher court. Okay. Now, next comes your Lok Adalat. See students, the Lok Adalat was set up in India for the first time in the year 1985, and it is believed that this Lok Adalat it provides cheap and speedy justice to the people of India. Okay. Now, this Lok Adalat was set up in the year 1985, and the date first met at New Delhi. In a single day, the Lok Adalat solved around 150 cases. Okay. And usually this Lok Adalat, it gives its verdict on the spot itself. Okay. It is headed by the retired judges, and for pleading to the Lok Adalat, you don't have to hire an advocate. You can directly go to the Lok Adalat and you can definitely file your case. Okay. Now, this decision of the Lok Adalats cannot be challenged in any other court. The decision or the whatever verdict has been given by the Lok Adalat, it cannot be challenged in any other court. And the jurisdiction and the working of the Lok Adalat is faster than any other courts in India. Okay. Now students, so this we have already done with your Supreme Court, your High Court and the subordinate courts in details. Now we are going to study about the different type of cases in India. There are two types of judicial cases. First is civil cases Second is criminal cases. Now, this civil cases, it deals with disputes among the property, in the property, okay. It may also involve cases of divorce, okay, breaching of contract and all this. This all comes within the civil court. Now, civil cases, sorry. Now, in case of a civil case, what happens, students? The claimant, okay, or the person who wants to claim something is called a claimant. In this situation, in civil cases, the claimant may definitely ask the defendant, or who has filed, who has done the mistake, in fact, about his claim, or he can charge some fine, monetary fine, okay, in case of civil cases. Now, civil cases are very petty cases. This can be also solved outside the court also, okay. Now, next comes your criminal cases. In case of criminal case, anything that goes against the society falls within the criminal case. That may be a robbery, that may be a physical injury, it may be a drunken driving, and it can also be a murder. Okay. Now, in this situation, the person or the criminal is put on trial, and the punishment can also be a fine, it can be a lifetime imprisonment, and it can be a death sentence also. Okay. So, these are the difference between civil cases and criminal case. Now, I am going to discuss with you the last topic, that is PIL, or public interest litigation. This is the last topic of the chapter. PIL stands for public interest litigation. Actually, this litigation or this initiative has been taken by the judiciary, keeping in mind the poor people of our country, or the non-prosperous section of our country. Now, what happens in case of a PIL? Actually, in a country like India, many of the people cannot file a case in the courts due to lack of money, just because they cannot hire an advocate or a lawyer. Okay. So, and violation of fundamental rights for the poor people is a common issue in country like India. So, in that case, the government or the judiciary has taken up an initiative of introducing PIL. And what is the task of this PIL? Under PIL, a group or an organization can file a case directly to the High Court or to the Supreme Court regarding the violation of fundamental rights. Okay. And after that, the High Court or the Supreme Court, they may they may utilize their writs or their special power to fight against this criminal system, or to fight or to provide justice to those people whose fundamental rights has been violated. Okay. So, we can also say that PIL works mainly for the poor people. They mainly work for the poor people or the non-prosperous section. Okay. And this poor people can be represented in the High Court or the Supreme Court by their organization or by any particular group. Okay. And in that case, the High Court or the Supreme Court looks into the matter and they solve the cases related to the violation of fundamental rights. Okay. So, that is the end of your chapter, and thank you.